is April 26, 2018. My name is Tanya Richard. I'm Deputy Commissioner and General Counsel here at Oath, and am appearing by designation of the Chair, who's unable to be here today. So I'm calling the meeting to order, and I'll ask if there's a motion to adopt the minutes of the last meeting, which was on February 22nd. Motion, and votes in favor? Okay, all votes okay. Great, thank you. All right, so the next order of business are DP's request for cease and desist orders. Mr. Cuny.
Right, thank you. Good morning, I'm Russell Pecunis with the Bureau of Legal Affairs at the Department of Environmental Protection. DEP has built up some extra business over the last 2 months since we had the last board meeting. So instead of the usual number of cease and desist requests related to failure to install backflow prevention devices, for this meeting, the department is requesting that the board approve 50 of these requests. In each of these cases, the building owner has been served with a notice to install backflow prevention devices, has been issued a summons for failing to comply with that order. The summons has been adjudicated against the building owner, and the building owner continues to be in non-compliance. So in each of these 50 cases, the department is requesting that the board issue an order to cease and desist.
Okay, and votes in favor? Okay, none opposed?
Favor as well, I guess.
Okay, thank you.
So the department also has several requests for cease and desist orders under the air or noise codes. So the first thing that I should mention is that the request related to Congregation Yetev Lev Incorporated at 427 Broadway in Brooklyn is being pulled for this board meeting as per my commissioner's instructions from yesterday. They have apparently hired an engineering firm to correct the odor problem from this matzah processing location, and they want to give them a month to see if they follow through on correcting it before they ask the board for a cease and desist order. So that request is being tabled, potentially to be brought back at the next meeting. With regard to the other three, which are all related to the noise code, the first one relates to Tripty USA Inc., which is a restaurant located at 2588 Broadway, a restaurant called Awad, A-W-A-D-H. They have been cited on 3 occasions at this point for excessive noise from the kitchen exhaust, and based on their continuing failure to come into compliance, DEP is requesting that the board issue an order to cease and desist.
Okay, and votes in favor? Okay, all in favor.
The next one is for a gym, CKO Kickboxing, located at 310 East 23rd Street. This location has been repeatedly cited for excessive noise from the sound system. Apparently they have classes where they play very loud music. They've been cited 3 times for this excessive music, still have not corrected it. Although the first time they came in, they did submit evidence that they had corrected it, as a result of which the penalty was mitigated to 0. However, they were then re-inspected twice and have been found in violation 2 more times, so they did not in fact correct it. And based on the repeated violations and continuing failure to come into compliance, DEP is asking the board to issue an order to cease and desist.
Okay. Votes in favor? All right, all in favor.
Okay. The third one under the noise code is Cheese Boat Incorporated. I don't know if that's the name of the restaurant or not, but it's located at 80 Berry Street in Brooklyn. This is another noisy kitchen exhaust. They have been cited 5 times for noise from this kitchen exhaust. And due to the repeated violations and continuing failure to come into compliance, the department is asking the board to issue an order to cease and desist.
Okay, votes in favor? Okay, unanimously.
And finally, the Bureau of Wastewater Treatment is asking the board to issue an order to cease and desist to Tenzan New York Corp., which is located at 285 Columbus Avenue in Manhattan. This location was originally inspected in August of 2016 and was issued a summons for not having a properly operating grease interceptor. A second inspection observed that condition had not been corrected, and in addition that a separate, different grease interceptor was full of excessive hardened grease. So a second summons was issued. Third inspection showed that the one interceptor was still missing its baffle, and that 2 other grease interceptors were overloaded. And a commissioner's order was then issued requiring them to have a waste hauler clean out the interceptors at a minimum once every 30 days, and to submit written proof of these cleanings to the department upon request. On several occasions in 2017, summonses were issued for failure to comply with that order. And finally, the respondent, in addition to failing to appear for several of the hearings on summonses, did not appear for a mandatory compliance meeting in December. And due to this long history of non-compliance, which continues, the department is asking the board to issue an order to cease and desist.
Okay, all votes in favor? Okay, and motion carries. All.
Thank you very much.
Okay, thank you, Mr. Kunis. Okay, next on the agenda are pre-sealing reports.
Good morning, everyone. I'm Becky Zidias. I'm the managing attorney for Manhattan Life Hearings for Oath, and I'll do the presentation in lieu of Kelly Forster, who's on the vote to attend today. We have 29 pre-sealing reports, including a water shutoff, and 1 post-sealing report for today's board. 28 of the reports involve backflow violations, 1 report involves a sewer violation, and 1 report involves a noise floor violation. With regards to the backflow sewer pre-sealing reports, there are 28 of them. In 17 of the backflow cases, the hearing officers recommended no sealing or other action based on respondents' evidence of compliance presented at the hearing. In 10 of the backflow cases, the hearing officer agrees with DEP's recommendation to discontinue the C&D proceedings because DEP has determined that the required devices have been installed and respondent is now in compliance. Likewise, in the sewer case, the hearing officer agreed with DEP's recommendation to discontinue the C&D proceedings because DEP has determined that respondent is now in compliance. With regards to the water shutoff, it's a backflow pre-sealing report. the hearing officer recommends that the water be shut off. The respondent in this case is Broadway 111th Street condominium. The premises in this case is located at 2851 Broadway, New York, New York, and it is a residential building with approximately 147 units. In November 2013, DEP issued a commissioner's order to the respondent ordering the installation of a backflow prevention device at its premises. The commissioner's order warned the respondent that failure to comply could result in termination of the water supply to the premises. In March 2015, DEP issued a summons to the respondent for failure to comply with the commissioner's order. The summons was sustained at a hearing in February 2017. In June 2017, DEP determined that the required backflow prevention devices had not been installed at the cited premises and requested that the board issue a cease and desist order. On July 2017, the board issued a cease and desist order directing the respondent to appear at a special hearing on August 15, 2017, to show why the water supply to the premises should not be shut off. At 8 hearings between October 2017 and February 27, 2017, the respondent's representative stated that there is a Department of Building stop work order on the premises that has not been resolved, preventing the respondent from complying with the commissioner's order. The case was rescheduled twice and had been adjourned 8 times since the first pre-sealing hearing on October 3, 2017, for the respondent to comply with the commissioner's order and to submit test reports. Respondent's representative was advised at the hearings that the water would be shut off if the respondent continued to ignore the order to comply. At the last hearing on February 27, 2018, the respondent's representative offered no evidence whatsoever of any progress toward achieving compliance or any specific information as to what is being done to resolve the stop work order on the premises. DEP recommended at the last hearing that the water service to the premises be terminated since no evidence of respondent's progress or compliance was presented. Based on the lengthy history of the case and respondent's continued failure to comply with the order and to provide any specific information as to what is being done to resolve the stop work order on the premises, the hearing officer recommended the water supply to the premises be shut off. There is one noise post-sealing report, and that summons was issued on November 26th for noise above allowable levels from respondent Fairway Broadway LLC with regards to its kitchen exhaust equipment at its restaurant at 2127 Broadway in Manhattan. Decisions were imposed with penalties imposed and ordering that the respondent comply with the noise code forthwith. Respondent failed to comply, and on October 26, 2017, DEP requested that the board issue a cease and desist order to the respondent. On October 26, 2017, the board issued a cease and desist order to the respondent, ordering that respondent to appear at a hearing to show why its equipment should not be sealed. At the pre-sealing hearing on January 30, 2018, at which time the sealing of the equipment was stayed pending inspection via DEP. A subsequent inspection showed that the equipment was operating in violation of the noise code, and the equipment was sealed by DEP on March 12, 2018. At a post-sealing hearing held on March 27, 2018, DEP presented proof that the exhaust unit was now in compliance with the noise code upon inspection as of March 23, 2018. At that point, it was unsealed by DEP because respondent was in compliance. Based on that proof, the hearing officer recommended that the equipment remain unsealed only if an initial and subsequent re-inspection of the equipment for a period of 180 days showed no violations. That's my report.
Okay, thank you. All right, prepared to, is there a vote?
Can I-
Yes.
Why don't we go from the backflows first?
That's a good idea.
Yeah.
Okay, so we'll go by groups, okay.
Right, so
All
there
right.
were,
Well, not all of the backflow,
not all,
not the,
not the shut off,
Not
the
right,
shut off,
right, the
right, the
27,
backflows
27
excluding,
backflows.
yes.
Okay.
Okay,
what I'm covered.
all right,
How
so,
many backflows before the 27 or 28?
28, including the sewer.
The one, okay, so the
Yeah.
20, oh, so the 28, so we'll vote on the 28 backflows.
okay, the 28 backflows, that's what's pending, and those in favor? Okay, so all in favor, and so the motion carries us to those.
And then what about the
It's
discontinued?
one post-ceiling, which is the noise code.
The one post ceiling. All in favor? Okay, and that's unanimous vote. And now, what's remaining is Broadway 111th Street condominium.
Correct.
Yes. Yes.
Yeah, I have an issue with shutting water off for over 100 people who are living there. no matter what the circumstances, that seems to lose your client. I mean,
That concern
why
does
is it
come
that
up.
some of the other regulatory agencies can correct or put on the tax bill or what have you? There are other methods to correct problems and or fine entities. I mean, what are you doing with the potentially elderly person who lives there and collapses from dehydration because her water shut off or his water shut off? I just don't, I mean, I think we've come a little farther than, a commercial entity, I don't have an issue with that, but when you have a multifamily of some sort, I don't see this. Why is the city not putting backflow preventer in and charging them? And if they're not paying, why don't we see that flow through onto their tax bills? And if they don't pay them, then we put tax liens on them. What are we doing here? This
So
is not-
let's address the question, and I'm assuming you have a similar one, do you want?
Well, can I just add to that? I have a specific concern, which is that, given what seems to be the situation here was that there was a stop work order. I guess my concern is that the landlord may be using this as an opportunity to get the building vacated because they have improvements they want to make to get a larger return on their investment. So I have a big concern about landlords using the city process actually to their advantage in terms of removing tenants that maybe are rent stabilized or something of that nature. So I mean, if that concern could be addressed, and Deborah's.
Okay. All right, so before Mr. Pecuni's, I just want to note that the first commissioner's order in this matter was signed in November 2013. Okay.
So it's been 5 years that they've had to clear up the issue with the buildings department. This is a condominium, so I don't think there's an issue with a landlord wanting to kick people out of the building. I just want to clarify that I don't think Commissioner Sapienza is going to actually sign off on turning off the water to a huge condominium building with 146 units, however many units there are. These occasional backflow cases that get to the point where we recommend water shut-off to the hearing officer are almost all with the same high-volume rep. He comes in over and over and over and over and over again with no information. There is no other recommendation that we can make. We cannot go into the building. The issue here is that because of the stop work order, they cannot get a buildings department permit to do the work. Okay? They could go install a backflow prevention device on the pipe, but they can't generate the test report that's necessary to show compliance without a buildings department permit, which they can't get. And I believe in this case, the stop work order is related to plumbing work without a permit. Sometimes the buildings department, if it's a stop work order related to the elevators or something on the roof or something, they'll give them the permit to install the backflow device, even if there's a stop work order on the building. I believe in this case, the stop work order does relate to illegal plumbing work, and that they will not give a permit for until it's corrected. Our hope and our experience based in the past is that when we send a crew to the building and they start painting the sidewalk and putting notices on the outside of the building that the water is going to be turned off, that the condominium owners will go shrieking to the managing agent, what is going on here? Why haven't you taken care of this? And it will get taken care of, okay? If it's not, again, I seriously doubt that Commissioner Sapienza is, at the end of the day, going to say, turn off the water to this building, which of course makes it uninhabitable.
Correct.
But there's nothing else that, at some point, there's nothing else that we can say because in the commissioner's order, in the law, and in the cease and desist order issued by the board, the remedy for noncompliance is terminating the service. So that's the only thing that we can recommend.
I
So is
understand that, but I think we need to change that.
Well, is the situation here that, I mean, is your belief the situation here is that the representative that's appearing, like, is not, I mean, the people that live there, they have no idea that this is
I don't know
going
who he's
on?
talking to. He's a lawyer. He comes in and says, I have no information. My client hasn't responded. I'm assuming he's talking to the managing agent or the condo board. I don't know which. I'm not privy to that.
And since it's a condo with multiple owners, nobody has sent notices to all of the owners.
I mean, our hope again is that when we post big red notices on the front of the building saying that the water is going to be turned off, that people will then go to the managing agent and the condo board.
Right, but
How much time-
And
that's
they will
not
get
done
this
before
resolved.
the vote. That's, you want us to vote on this and then do that. I'm saying. why
Because we're not
don't we
authorized
vote?
to go turn off the water until the
This
board.
process needs to change.
But is there a way to, before going to this step of actually turning off the water or potentially turning off the water, to try to contact the owners? I feel like to
I mean, they're represented by
penalize,
council. I
to
mean, I don't
penalize
know.
these residents because of the failings of their managing agent, and I know I have no sympathy for the management company. But I feel like it must be a situation where the people that live there, and I guess if it's really a condominium, they own their units, they must not know.
I can't.
Right, and what you're saying is the notice won't be given until we vote on this and already say we're shutting off the water and have an issue with that.
And if they,
I have a question. How much time passed from the time you print the notices to the time that an actual shut off occurs?
Again, in this type of a residential situation, I think what the commissioner is going to authorize water and sewer to do is go paint the sidewalk and put up the notices on the entrance to the building saying that because of the non-compliance with this order, that the water to the building is going to be turned off. I don't think he's going to authorize following up with actually doing it.
But usually the follow-up will be.
Well, it's not even, there have been so few cases that have gotten to this point that I can't say that there's a typical scenario, except that we have never turned off anybody's water for this. As soon as they see the guys out on the sidewalk and in the street with the spray paint cans and the notices on the front of the building saying that the water supply is going to be terminated, we hear from somebody immediately, and usually, I mean, we had one, the last one the board approved was for a Jewish school in Brooklyn. Same rep, same situation, stop work order from the buildings department. As soon as we went out to the building, we heard from them, they got that stop work order resolved, and they got the thing installed, and as far as I know, they're now in compliance.
but how was that effectuated? There was some stay of the ceiling then, to do
Well,
that?
we first of all, one of the things that we actually have to do, because they do want to become much more aggressive with enforcing this, the ones that come to the board for shut-off are very, very rare. Okay? These cease and desist orders that the board issues includes a statement that says that if you fail to appear for the hearing, you're subject to shut off without further proceedings. We have at least 200 of those cases where people have not showed up for the hearings and are still not in compliance. And they want to be much more aggressive about prosecuting those cases. So one of the things that we need to do is speak to the other city agencies that might be concerned, like the buildings department and the health department and the fire department, and set up a protocol for doing this.
NHPD.
And HPD, which is not a member of the board, but yes, and HPD.
Okay.
So,
is that-
I mean, if you want to table this and say we'll go out and proceed to paint the sidewalk and post the notices, and then if there's still nothing by the next board meeting, I mean, we can do that.
I would like to use this as an impetus to get them to deal with this situation.
But I mean, the problem from our point of view is, especially where they've chosen to be represented by council, and they're coming in over and over again saying nothing.
But if they're, I mean, if their council's effectively committing malpractice,
That's another issue that I can't speak to.
Well, I mean, it seems to be what may be the case, but then
We don't know.
we don't,
We
I'm
don't
not,
know- we
okay,
don't know
I'm not,
who's
and I'm not
being
saying
told.
that's, yeah, I'm not saying that's necessarily the case, but I think there's, if this is happening repeatedly with the same representative, where they're coming forward with
Again,
no
repeating
information.
again, the last one was also the same rep.
And there are provisions in the rules about representatives that are not, that can be banned from the.
Yes, but again, we're projecting, we really don't know. We don't know what management could telling them to stall. We don't know. We haven't heard any
That's
complaint from the
exactly right.
respondents, so.
That's
you know.
Right.
They're
And I
running
say-
out, it's highly possible that he's running out the clock, and guess what? He's highly successful, because for
Yeah,
5 years they
exactly.
haven't had to pay.
But the question I have was, you made a comment about compromise, about painting the sidewalk and putting up signs. Now, if the board doesn't order that, how are you putting up signs? You can't put up signs unless you have the board order.
Well, that's why normally we don't do it until there's a board order to do it.
And this attorney is just representing the management agent?
Well, it's a
they're hired.
condominium,
So it's
so
sponsored,
condominium will
sponsored.
either, I'm assuming he was hired either by the condo board or the managing agent. I don't know.
Because then, if we're gonna go off and think that the members, the condo members don't know about this, if he's just representing the management agent, maybe the condo members don't know.
We don't know.
That's
I
right.
don't know
And
what they
we
do
don't-
or do
and
not.
of course, if you have an attorney, you can then go through that and say, let me give notice to the condo president and the other board members.
we-
No, but they've been noticed for 5 years that this needed to be taken care of, because the original order from 2013 was not served on the attorney, it was served on the condominium.
Might I suggest a compromise here, and I'm just pitching this out. Has Mr. Poljar come with a respondent, with anybody in the management company? Do we know if he comes to the hearing with anyone or without?
That I don't know off the top of my head.
Because we could have one more hearing forcing him to come with his client, so we know that the client is informed of this and is not taking care of it, and then bring this back to the board next time. Because I think the general concern here is that some people feel the client does not know what the attorney is or is not doing. I don't know the history of this much, I really don't, I didn't study it, but it's just a suggested compromise here.
We can do that.
Well, I mean, could I suggest one other thing that could happen at the same time? I mean, could a form letter be sent to the occupants of each of these units concurrently with that, so that they're actually told your water is likely to be shut off, like this is the last chance.
How many units are there in the building? I mean, somebody's gonna have to look up 147 names
So
and.
maybe
Say that.
just the.
No, just address it to owner or occupant of,
Resident.
But you mean just put them in the mailboxes at the building? And we'd have to get into the building to do that, but.
Would it be
Or you
just
can mail them.
easy just to contact the co-op board president? Because we don't know if this person is just a representative of the management or giving notice to the other co-op members.
I mean, all we can do is we could send an inspector to the building and see who the inspector can locate at the building to talk to. I don't know whether there's an office in the building, or we don't know who the managing agent is. I mean, I'm assuming they have one if it's such a big building. I mean, we can send an inspector to the building, but again, I mean, the fact that we have to go through all these gyrations for something that they were ordered to do 5 years ago and hired an attorney to handle seems a bit,
I mean,
Sending
what
letters
we
to
are somehow
residents.
presuming,
Same address.
what we're somehow presuming is that there is a legal structure that requires the managing company to then go to the condo board and make them avail, like, all of those things are already in place structurally in the law, right? If they're not complying with their response, there's nothing we can do about that.
Well,
And-
actually, we're
but
changing
to the
the
extent that Russ is willing, to take an additional step, I mean, I think that may work out.
try sending someone
But
over
there's
there
nothing
and see what
onerous
happens.
about this 5-year process. I
And
cannot
that's not the
imagine
point.
that it's not
That's not
been
the
put
point.
before a board in 5 years.
Well, I'm assuming somebody had to approve hiring the lawyer, so.
Right, and it was the board president, because the relationship between the management company and the actual condo board, the agent is acting just strictly as an agent, so ultimately the condo board and the president would be responsible. In terms of the notices, I think that's a great idea, but I know it's onerous on the agency. Maybe as a compromise, if there are notices, perhaps they can just go inside the building and post them in the hallways near the elevators. This way all the residents use the elevators. They would be on notice.
Something like that would even be.
Instead of mailing, because I know the
Putting
block
up-
and lot is really,
You know,
just-
this,
If they're bad actors.
but they'll throw out the mail. I mean, it's at least everyone's know.
I can commit to sending an inspector over there without knowing what the situation is at the building. I don't know what the result of that is necessarily gonna be. I can commit to them posting notices. I cannot commit to them putting 147
Okay.
notices in.
That's a good
mailboxes.
idea, posting notices is a good
At the
idea.
same time that they paint the sidewalk and they put the big signs outside, just put them by the elevators.
They can't paint the sidewalk.
They can't do that unless.
But that's the bottom, that's what he's
Well,
essentially saying. is that
painting the
they're
sidewalk
already-
just means there's paint on the sidewalk. It doesn't mean that we're gonna do anything. If that helps to focus people's attention, then we could send a crew over there to do that. Whether they, we've never done it before without the board telling us to do it, but
Well, we could approve, another option is we could approve the sealing to occur a certain amount of time after those steps are taken, to allow time for
I mean,
the.
what we could do is we could send the crew there with the paint and the notices, but not take any other action until the next board meeting.
Okay,
And then we'll report back on whether that has had any effect. And we'll try to get in touch with somebody other than the lawyer, either at the managing agent or the condo.
I mean, I also would just say that it might seem appropriate if this has been an issue with this particular attorney, that some investigation.
We wouldn't know
By
if there's
oath.
an issue unless it were reported. I mean, again, we don't know what the instructions are. We haven't had any report from management that he hasn't been represented. Well, we haven't had any complaints that I'm aware of.
But he might be pursuing a strategy which he tells, and his clients might be approving of it, which he sees as effective, which is, as you said, running out the clock. But is that,
I feel as a lawyer, you do what you.
Yeah,
Right,
it
I'm
seems
sorry,
effective.
Right.
He's being effective, he is running on the clock.
What is he using?
but ultimately, is it effective if he's putting in peril the water service to a residential building? Is that really being effective? It might be effective in the short term, but ultimately, is that?
It'd be speculation on my part. They may just figure, well, the city will never turn off the water to this building, so.
And the attorney is representing the condo board and the president, he's not representing all the individual unit holders, so the unit holders will probably have to get their own legal
I
representation.
think so.
I just have one suggestion, I'm sorry, I just have one suggestion. When you have someone from DEP actually making that call to the building, make sure it's an attorney. Because the they're represented by counsel, someone's represented by counsel, so we can't have another attorney speaking to someone at the building.
That's
So it has to
already-
be a non-attorney, so maybe some inspector, so. it can be
Well,
a
I mean,
client to
we
client.
would send an inspector who would speak to the super or whoever is at the building and try and get contact information, because right now we don't have anything but the mailing address.
So it has to be client to client and not counsel to client.
That's fine.
All right, so, resolution?
So we'll report back at the next board meeting as to what happens when we go over there, I guess. But just to make clear, there will be no termination of the service until we report back to the board. Okay?
All right, so then, we have not taken a vote on that. We'll sort of withdraw it for vote on this particular case,
Right,
right?
we'll table it for now.
Table it.
Tabling the vote for this particular one.
One more month after 5 years. Hopefully there won't be a major,
Thank you.
And then, what did the building department say about the board when they did this plan? And it's a legal. Or do they just never submit any plan?
Well, the process is a two-step process. You have to submit plans to DEP to be approved, and then the plumber has to get the buildings department permit. So I think that they did, the hang-up is with the buildings department permit, not with the DEP approved plans. It, because of the stop work order and that it's plumbing related stop work order, that they cannot complete the process.
You have to be doing
Plumber
it all
can't have
as
I don't,
individual.
yeah, I don't really understand that on one level though. I mean, I understand exactly what you're saying. But the DOB also has the ability to come in the middle of the night, slap an emergency work order on the building, and throw scaffolding up the building over $1 billion, do what they want to do. So this could be treated as an emergency situation, and they could go in there. And they could backfill the owner. So why that process can't be
I don't know if
followed
it's a
in
matter
this
of
kind
just,
of
I don't know if it's a
instance
matter
when
of
it
just
can
a
and
penalty.
others, it's not
I think it's a
acceptable.
matter of whatever they did to the plumbing system that's illegal.
That's not the point. The city comes in, they go into their own emergency order. They bypass the owner. If you have like structural instability or facade issues or whatever, it could be harmful to the public. DOB can come literally in the middle of the night with an emergency work order, put scaffolding up in front of your building and backfill the owner.
Well,
So
this is
why
one
is
of the
this not
reasons
an
why,
emergency
because they do want to
situation?
become much more aggressive about doing this, that we want to set up a protocol with the other agencies
Exactly.
where we will have a contact person at each agency that will be notified that there is a pending shut-off, and each of those agencies then, depending on, sometimes it may be a fire service that needs to be shut down, so the fire department would need to know. Sometimes there may be health department related
No, but-
issues if water was being turned off to a restaurant or something of that nature.
No, but
So
I'm
that's-
saying you circumvent it. You actually have the ability to go in and correct and backfill the owner.
We don't have, maybe the buildings department does, but we don't.
Yes, DOB should be able to go in there.
Well, that's up to the buildings.
Well, that needs to be dealt with, and if this has to be the case, it turns that, so to speak, fine, but I will never vote to shut off water for multiple residents like that.
Well,
That's
and again,
insanity.
I just, the first thing that I said back at the beginning of this is, I don't think our commissioner would ever tell us that we could go ahead and shut off the water to this building. But we have to menace them and threaten them into complying, because what's happened to date over the last 5 years has not gotten them into
I
compliance.
agree with you, and because the
Okay, we have
process
to
is
move
so
on. We
ineffective,
have to
it needs
move
to
on.
be dealt with.
All right, so is there a motion to go into executive session to discuss judicial report? Okay, all right, thank you. All right, so we're back on the record, and no further matters pending before the board today. We will adjourn.